point across and thinks very highly of you. And then here's another one from, it looks like, is it Teresia Robinson? I think the T is marked out. And that's a very nice letter as well, written on your behalf. How do you know this person?
She's my current supervisor.
Your current supervisor. Which my current supervisor would write me a nice letter. My wife. Once. Marcy thinks I'm doing well. She said, needs work.
Yeah.
Needs work, but yeah, I'm doing well. This her.
It's improvement.
I'm getting better, she said. Oh. Okay, earlier here, the defendant pleaded, well, it's not showing, entered, has she already entered a plea?
Yes.
Yes.
Okay, this is not showing on the file. Entered a plea guilty to misapplication of third-degree felony of fiduciary or financial property. And the agreement is that the defendant would be placed on probation of a type and length at the court's discretion, and restitution in the amount of $8,966.09 would be part of the order of probation.
Yes, she paid back a big chunk. That's just what's left over.
Is that right?
Yes.
What is the balance?
Yeah, that's the balance. 8,000 the balance. She paid off about 24,000. It was 37,000 total.
Oh, okay.
That's the balance of it right now.
So the balance is still $8,966.
Correct. Yes, we were trying to get that done before we finished the case.
Okay. How do you have a plan? What is your plan on getting that paid back? Because that's what's in, the quicker you pay it back, the quicker you get rewarded.
Yes, right. Yeah, back as I can work.
How is that going to be done in your plan though? Do you have like a monthly plan
Yes, sir.
about how much?
At least 300 a month.
Can you do that?
Yes, sir.
All right, because I'm going to order at least 300. All right.
Judge,
All right,
there
the
is
parties
there
had
is
an
a-
opportunity to review the report. Are there any corrections or changes to it or comments? First of all, defense.
No, you're not.
Okay, state.
Judge, there is a memo that was added on from the complaining, one of the officers of the association, huh?
We just,
Yeah, just got it. So it should be, I don't know if it's in there or not.
it's not.
And Judge, I wouldn't
I
add
don't-
to that letter being part of the PSI. I think we were going to address that, but since I brought it up. Hughesby State says that a layperson shouldn't be giving, shouldn't give testimony on the position for punishment. Also, he was a member of the same association she was. I think I'm sure he's mad, but it actually doesn't really matter on our plea bargaining anyways. But I'm just making that actually the record that it's an improper part of the PSI.
What's the state say on that?
Judge, this was an interested party, one of the people that belonged to the association that she stole from. So it'd be like a complaining witness that is voicing their opinion about the plea bargain agreement, and as well as the way it affected the members of the organization that she took from, and the trust that they placed in her before she took this money.
What's the organization here? The sheriff's?
The sheriff's, yes, sir.
So a non-governmental entity made up of governmental entities.
Jefferson County Sheriff's Association.
Yes, sir.
Yes. Oh, it says right, Hughesby State, 787 Southwest 2nd, 193.
Once again, has everybody read this pre-sentence report and
Yes.
no other changes?
That'd be the only objection, Judge.
Okay.
No, everything else is correct.
I have no objection, Judge.
I'm sure you're reading this in the report, Judge. This is it's not like stealing cash directly from. It was mostly using the credit card for unauthorized purchases that were personal, not for business purpose.
Okay, so the point you're making that.
I just want to make sure that you knew was that, like, just like robbing the safe in the middle of the night or anything. I just make sure that you knew where that was, how the money came. We figured out what the restitution was. So I had to look for non-association versus association. That's where there was a difference in the restitution versus what was initially alleged as well.
So, no, you're trailing off. Go ahead.
It's as long I'm just making sure that you saw that what that was in there is that it was the use of the credit card, not just going in like pulling cash out of the safe or something.
How does that?
It doesn't change anything.
Yeah, that's apples and oranges.
Yeah.
Both fruit.
Yeah, they're supposed to. It's not like she's wearing like a burglar suit, go in the middle of the night and break into the safe. That's all I'm getting at. But there's no excuse in the context, as you see, she's remorseful.
I understand, but once again, she was put in a position of trust and misused that
Yes, Judge.
to the detriment of the organization and sometimes this happens here, and there's a big difference between people who are funneling out proceeds and then they're buying food.
Well, this was for a lot of this was for personal family stuff. There's
Cruise payments, cheerleading fees.
truly that's children.
Come
yes.
on.
But it's
Anything else? I mean, that stings. You know it.
it does, and
I mean, we're not talking about this is having a good time.
right. She's also lost her reputation, her career,
Well,
everything else, and is paid.
what else could be expected
Nothing.
in this?
Nothing.
She betrayed a position of trust, and when you're given a position of trust, you have a lot of flexibility and freedom, and numerous people rely on the integrity and the honesty of it. And here we're still out. I mean, that was a significant amount. Good thing you paid as much back as you can, because a lot of times folks don't. But here it's still thousands of dollars are still missing, and we're talking about losses since August of 21. This is over 4 years later, and the loss of value of it, is still, that adds up. But
Yes, Judge. And we've been doing it for some time too. I think she paid this back before she was charged.
did she pay back with interest though?
Oh.
No. I know that doesn't happen, but we all agree it ought to be.
I understand.
It ought to be. It's just not the way it is. But nonetheless, is there, even when they get back the last dime of the actual money lost, they've lost the value over 4 years of it, so they're out.
It's not, and I'm not discounting anything.
I know.
I
Let
know.
me see this case you're talking about.
The difference that we're talking about is whether it's a deferred probation, whether it's conviction or not. And you can also make a finding that is not in the interest of justice to ever steal this. And I'd be perfectly happy with that. I just don't want her. I want her to just pay for what she did, but not be forever
Yes, sir. I
cursed for it. And that was the
Good.
kind of the
Well,
the
you're
issue.
being a good lawyer. That's you're representing your client vigorously. Good. You many times folks don't hear, and that it's always a good thing, because that's important.
And I didn't highlight the part of that, Judge, but it's pretty much just the last point of error. Just says that lay witnesses should not give an opinion on proper confinement and punishment,
Mhm.
and that's really all it is. A lot of the other points of error don't matter for us.
I'm going to highlight.
Oh, yeah, absolutely. That's your copy, Judge. I just didn't want to touch your copy if I was giving it to you. I tried to be suggestive. I guess it's just argumentative instead.
Okay. Let me see that letter.
It's right there, Judge.
No, here, you can have that. Okay. You were referring to obviously the last
Just
two of the last three sentences.
Correct, Judge. That's
Okay.
correct.
All right. And the court has, the district attorney's office has requested the court consider this. And this is referred to as a supplemental PSI report memorandum. And it's from Caleb Mitchell, who is president of the Jefferson County Sheriff's Association, I presume. And your objection is noted, and the court is not going to consider the first and second sentence of the last three sentences of that, but I am going to consider everything else.
Yes.
Because everything else does speak to the harm that occurred to the organization, which is the entity that which is the actual victim in this case, the Jefferson County Sheriff's Association. So, but once again, people from time to time make comments about what the punishment should be, but only the jury and the court really has that final determination, depending upon what the defendant elects. So, anybody else want to add something here?
Nothing further, Judge.
Okay, your request on behalf of the defendant is what?
I'm requesting for a deferred adjudication, and you are very welcome to make a finding that it's not in the interest of justice to ever be eligible for non-disclosure. The statutory authority does allow you to do that. And if you do make that finding, then she can't seal this in the future. And I know that's the big issue is they don't want her to be able to hide this in the future. They wait down the road to ever, be put in that position of trust. And we have no problem with you making that finding, Judge. I think that would be highly appropriate in this case to make the Jefferson County Sheriff's Association possible in their feelings.
Anything else?
And of course, the restitution, Judge, we know she must pay back the last part.
And
Judge, because of the position she was placed in and the organization she was placed in, a position of trust that allowed her to work without them looking over her shoulder because they did trust her, and then to come back and find out that she's taking money from them. It's not only hurt that, but it put a black eye on the association itself. So we're asking for a straight probation, that she have a conviction, that follow her everywhere so everybody knows, look out, because if she gets in financial trouble, this is a possibility. We want to make sure that we protect further future victims. And we also make sure that the position she's placed in know that they need to keep an extra eye on her if they do place her in a position of trust. So I think it's a fair resolution for the fact that she took it for such a long time, and for the money that she took and from who she took it from.
Okay. And ma'am, is there anything that you would like to add here, Ms. Lewis, before the court makes its decision? This is your time. Your attorney has
I prefer
spoken for you.
I prefer she wouldn't, just always makes me
Well, it's
curious.
whatever you wish, and you certainly can follow your attorney's advice. Yeah, nothing else?
Yes, sir.
Okay. You did make a statement to the pre-sentence officer, and here it's related in 2 paragraphs here on page 2. So you stand by that. Okay. Anything else?
That for the judge.
All right. If nothing further, the court is going to find that Ms. Lewis, you have pleaded guilty in this case to misapplication of fiduciary or financial property, a 3rd-degree felony. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your hearing to find you guilty beyond a reasonable doubt. One final thing, how much credit does she have on service? How much do you have any time serving in jail on this? You went in and bonded out, I guess. She says there's none. I trust that she would know better than anybody else.
Yeah.
One day. That was when you came in and then bonded out immediately, and they give you credit. All right, here's the court's ruling. I find you guilty beyond a reasonable doubt of this offense. And you are hereby sentenced, that's a 3rd-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. But I am suspending that and placing you on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You had a total loss. There was a total loss here to the Sheriff's Association in the amount of $37,102.91, of which a balance toward that replacement or restitution of those funds in the amount of $8,966.09 shall be ordered to be paid as a condition of probation. And you said, I think, that you could pay as much as $300 per month.
Yes.
And that will be ordered. At least $300 per month will be ordered to be paid toward restitution. There will be terms and conditions of probation, which are normal and customary. The court would also add for the record, this particular situation and crime involved a illegally taking advantage of a position of trust. You understand that. It's obvious that you have admitted in an attempt to resolve this in an appropriate way. I just wish we could have talked you into not making those choices in the first place, because these are clearly wrong. And something like this is ultimately going to collapse. Somebody's going to find out about it. There's going to be an audit. It's just waiting to fall. It's a shoe waiting to fall. And maybe that bothered you and kept you up at night. But nonetheless, you had, according to the pre-sentence report, 186 separate transactions that you illegally accessed since August of 2021. And these involved expenditures of that had absolutely nothing to do with the purpose of the money that was properly placed into the sheriff's organization, sheriff's association, that should have been used for the purposes that the sheriff's association statements in their incorporation and what that professional entity was entitled to use those for. And those are limited purposes, but it had nothing to do. It had absolutely nothing to do with what you accessed improperly and used those that $36,515.34 for, such as your daughter's cheerleading, childcare, school fees, rent, utilities, and personal subscriptions, and other personal matters, which also included airline tickets. And we can go on and on, but I think the point is made. You understand it. You have admitted responsibility and are pretty much throwing yourself onto the mercy of this court. And your intent to help your kids enjoy life and provide for them and what they wanted contradicted with the obligations that you had in your responsibilities of honest maintenance and control of the Sheriff's Association monies. And so when something happens like this, the price is serious, as it should be. I just wish I could have whispered in your ear, don't do this at the beginning. But you have accepted responsibility, and that is important. Now, these also, such a betrayal of trust also doesn't just walk out of here without the issue of I can assess up to 180 days in the county jail as a condition of your probation. What do the parties say to that?
Judge, in these kind of cases, the court has always given some that's a discretion as far as the time. I don't know, since she's paid some back, she should be given some credit for that.
I think
so.
Should, yeah.
So somewhere around 30 days, maybe up front.
Judge, now we want her to pay restitution.
Sir?
He's got $8,000 left. Putting her in jail is going to take her. I mean, she has a job that now she's going to pick a felon. We don't want her losing her job and not being able to pay restitution back. That really kind of wasn't our agreement on our plea bargain. We talked about internal probation is the length and the type, not the
Court's
condition.
discretion.
I understand that,
And
but that's,
but your argument is, don't hold me hostage.
Not holding you hostage, Judge, I'm just-
I know you don't, but
I'm giving Mike a hard time because he asked for jail.
you're
That's
vigorously,
what we agreed on. So
and
this
it's
is personally between me and him, not the court.
or
That was not, well, it wasn't part of the plea agreement.
Correct, it's not.
That's correct. It
and it's
wasn't.
my discretion.
I understand
I
that.
can do that up to
But if you-
180 days, and she's going to go to jail.
Well, with the
Anybody in a position of trust like this, it's going to go to jail. But what I'm going to do is, what are your days of work?
Monday through Friday.
Monday through Friday. I'm going to order you to serve 30 days in the county jail on successive weekends, beginning each Friday. You must report on it before 6:00 p.m. You'll be released Sunday, and that'll be for 15 weekends, successive weekends, as a condition of this probation. Do you understand? Can you work that out? When can you begin that? Today's Friday. I'm going to give you 1 week. Is that enough time? Beginning next Friday, on or before 6:00 p.m. in each successive weekend, until 30 days are served, or unless this court decides otherwise to reduce that time. Dustin, did you hear that?
Yes, Judge, I was making sure.
Okay.
That's clarified.
Okay, you just want to.
So next Friday.
Has discretion, and we'll see how things
Talk
play
to
out.
me. Okay.
And this restitution, let me ask you this. This still is not $8,966. Is there any possible way you're able to pay that restitution earlier than over time? I don't know. I'm just asking you that. I reward people who do that, if you know what I mean.
Yes,
Towards conditions of probation. Okay.
I